Justice Kavanaugh?
Try to tick through a few questions here. On Justice Alito's questions, you said independent agencies do rulemaking, enforcement, and some adjudicatory powers as well, but so do the traditional cabinet agencies do all of that too, or at least most of them do. So I'm not sure that helps you distinguish the independent agencies from the traditional executive agencies on the earlier questions, but I'll just leave that. You said you agree with, I think you said you agree with all the court's precedents.
Yes.
That includes everything in Myers.
We agree with the holding of Myers.
Do you agree with the opinion in Myers?
No, and a lot of the reasoning in Myers went too far, and that was part of what the court decided in Humphreys.
On the text of Article 2, we haven't talked a lot about the theory by which you get to the other side's position from the text. The first 15 words, the executive power shall be vested in a president of the United States of America. For the president to exercise that power, he needs subordinates. For him to, and he needs to be able to supervise and direct the subordinates, and to supervise and direct, he must be able to remove those officers at will. This is the theory. Otherwise, and this is what I want to get your answer to, otherwise a subordinate could ignore the president's supervision and direction without fear, and the president could do nothing about it. You agree that's the implication of your theory, correct?
That the subordinate could disregard the president's instruction, and that in some circumstances the president could do nothing about it. Yes, in some circumstances, but not under the FTC Act in the modern era of traditional independent agencies. If there was anything like malfeasance, if there was neglect of duty, so that would be associated with law breaking, as Professor Manners discusses in her amicus brief on the INM standard.
But generally, if the president says, I wish you'd pursue a more aggressive enforcement policy, and the head of the agency says, I'm not going to do that, there's nothing the president can do about that, right?
If it's just a matter of enforcement priority, that's right. And
or I would want you to issue a new rule in a particular way that does a particular thing, because I think, as president, it would be better for the American people, and the agency head says, I disagree with that, I'm not going to do that. You agree that that's okay under your theory?
That is okay under our theory. That's the judgment of Congress and the president, and as was pointed out in Ray Aiken, and as we've explained in our brief, this court's precedents don't stand for the proposition, Justice Kavanaugh, that we have to have those arrangements. They just stand for the proposition that the people's elected representatives in Congress and their democratically elected president in appropriate circumstances can come together and decide that vital interests of the American people, including preservation of liberty, and I don't think we should forget about that, including that can be effectuated by having these multi-member commissions.
Two real-world questions. You've mentioned many times you can just go to Congress to fix this. Well, once the power is taken away from the president, it's very hard to get it back in the legislative process, kind of the flip side of what we were talking about in the tariffs case. Because the Congress, the real world of this is the independent agencies shift power from the presidency to the Congress. Everyone recognizes that Congress has more control over the independent agencies than they do over the executive agencies. So Congress doesn't want to give that up. It's hard for the president to get new legislation passed that would, for example, convert an independent agency into an executive agency. Do you have an answer to that I think just leave it to Congress ignores the reality of the legislative process and Congress's desire to keep that power that they have had, that most people have recognized, over the independent agencies. That's a theory out there. I just want to get your response to that.
Yeah, I have two responses to it. One is that I don't think it's an accurate characterization of what's going on to say that Congress is aggrandizing its own power at the expense of the executive. I think, in fact, exactly the opposite. And a lot of these agencies—
That famous quote, the independent agencies are ours, by a leading member of Congress, that was just—
I will give you an example from the FTC Act itself. The operative provision from the very first version of the Act provides that this Act is all about defining unfair methods of competition in commerce. Full stop. How do you know what is an unfair method of competition in commerce? The statute doesn't say. It delegates that congressionally, constitutionally enumerated authority to an agency that the president has all kinds of supervision and influence over, and what is happening—
But much less than the executive agency. I understand your point there. I think I got it. Your brief refers to regulatory stability being a virtue served by the current overarching regime. I don't think a lot of the regulated parties really think stability has been a virtue of the regime because it goes back and forth when the agencies shift power. And so I think, unaccountable instability would be what they might say. So can you address why you think, and this is relevant to the stare decisis factors, I think, why you think regulatory stability is actually occurring at a lot of these independent agencies?
Yeah, absolutely. So two things. One is that part of the logic of that comes from this court's decision just last term in the Chevron case, where the court said you can have a lot of regulatory instability if every single time a new administration comes into office, all of a sudden everything can change. Now, that is a problem on steroids if petitioners get their view, because you don't even have to wait for the administration to change. The president could just on a whim decide tomorrow that everything the agency has been doing is wrong. Public reliance on stability presupposes that this is the whole point of the staggered terms requirement that this court explained in detail in Humphrey's Executor, that the whole point of this structure is to guarantee a modicum of stability that private regulated entities can depend upon, and that is jeopardized by at-will presidential removal.
Two more quickly. Hopefully you've used the phrase chaos and disruption if you lose, and don't strike down the entire agency. I think you used that phrase. I don't think that's what would happen if you lost, and I think you would agree with what I'm about to say, which is if you lose on the merits, the proper remedy is simply to sever the for-cause removal provision, not to get rid of the FTC. Do you agree with that?
I agree with part of it, but not all of it. The remedy is not to get rid of the FTC, but I think there's an analytically difficult question about whether the proper remedy would be to sever the for-cause removal provision as opposed to, depending on the nature of the ruling, maybe one isolated power that is deemed to be quintessentially executive and that generates the separation of powers problem.
Okay, last, sorry about the length of this, but this is important. Last, you said Congress, as a tradition, they won't depart from it, but the last 10 years we've seen two examples of first a single-headed independent agency and separately a double for-cause removal provision. So I don't think the idea that Congress is just following the model that it's used before is really sustainable in the face of those two experiments that we've seen in the last 10 years. That's just a comment from your point about, oh, there's a model and they just follow the model.
It is not an absolute rule, and there may be times when the political branches depart from an established model, and when they do so in constitutionally problematic ways, what we know from recent history is that this court will be there and there will be time enough to decide those questions.
All right, thank you for your answers.